Your name, please?
Hazel Rabin.
All right, ma'am, you have a set of allegations here. Burglary of a dwelling, bond $25,000. Criminal mischief, more than $1,000, bond $2,500. And petty theft, bond
Your Honor,
$100.
rather, I'm not too concerned about a bond hearing at the moment because these allegations are false, but I would like to confer with the public defender
You may.
privately.
No?
Okay. I had an appearance yesterday. This is second appearance.
I know. That's what we're going to do is we're going to go through it, okay?
Okay.
Let the judge get
Is
through it.
there still a warrant for a battery,
Yeah.
a false battery charge?
Right now, the judge is letting him get through.
Okay, but I'm concerned about that one, because that one's false too. All right, I'm sorry to interrupt, Your Honor.
Yes, we're fine, Your Honor.
All right. Now, I have no application for a criminal indigent status. Any prior history with the
Yes, Your Honor.
with the Office of the Public Defender?
Yes, Your Honor, she does have 6 misdemeanors, 8 failure to appears, which her last failure to appear was back in September of 2016. She does have Florida convictions for larceny, simple assault, petty theft, false information given to LEO, and possession of drug paraphernalia. No out-of-state history. And she is out on bond on a battery charge.
Your Honor, in my defense, I was homeless living with a crackhead.
Whoa, whoa, whoa.
Well, I was, in my car.
Hey, hold on.
So failure to appear, if I didn't get the notification, that might be why.
All right, there was a public defender previously appointed, I'm advised. So, Office of the Public Defender would be appointed at this time. Bond is stayed if that is still active. And let's see. I don't see the case or the division. Division 17, I'm advised. That's right, that bond is stayed.
Here's your sheet. Okay, your calls right there. He's not taking any action out in bond, okay?
Yeah, that's,
Keep it dry,
that's
okay?
fine. They always take my paperwork anyways. So, have a good day, Judge Prather.
Thank you. You too. All right, the next case is that of James Calixte, if I pronounce that correctly.
Yes.
All right, sir, you have a set of charges here. One is kidnapping on which there's no bond. Count 2, sexual battery on a person 18 years or older, no bond. And then the same allegation again, no bond. And once again, the same allegation again, no bond. Sir, do you want me to appoint a lawyer for you?
Yes.
All right. The Office of the Public Defender is hereby appointed, Division 20.
Your Honor, if we can be heard on the matter of the bond,
All right.
it's set bond when it's come in here for the purposes of the nature of the crime. However, the state, at this point, I don't believe that they're saying anything to the effect of the proof of guilt is evident or the presumption is great. So as such, I ask for a reasonable bond on the charges, Your Honor.
The state does request no bond, Your Honor, because this is a charge punishable by life, and the defense's counsel is right. It is proof evident presumption great, but in this case there are witnesses and the victim ready to testify and identify the defendant, and so to ensure the safety of the witnesses, the community, and the safety of the victim, the state requests no bond.
And Your Honor, if I may follow up on that presumption of the proof of guilt is evident or the presumption is great, we look at the four corners of the warrant, specifically in the warrant, there are no independent witnesses. My client did not confess the allegation, and the warrant states, quote, laboratory reports show that a match occurred during the DNA profile. However, the warrant doesn't talk about the degree of the match or statistic analysis. So at this point in time, I state, I'm asking this court that it does not support, the facts in this warrant do not support that the proof of guilt is evident and the presumption is great, and I ask for bond, a reasonable bond this time, Your Honor.
All right, now the affidavit for arrest warrant. All right, it states that DNA profile obtained from the sexual battery kit.
If I may follow up, Your Honor?
Yes?
The defendant does have a past conviction for battery in which the same MO was used, and it was committed October. It was a misdemeanor, but it was he pled guilty to that in October 24th, 2019. But the facts of that case match similar to this case in that he attacked a woman in the same area, Thornton Park, and he didn't get as far as he did in this case, but there's a matching MO.
And Your Honor, if I may, those facts of the case are not part of the warrant, and he's not being charged anything for the alleged crime or the crime that the state is discussing. Of course, that can come into play for the purposes of bond, the amount of bond, but for the matter of PBL or proof evident, the proof of guilt is evident or presumption of great, that is not part of the warrant.
All right, anything further from the state?
No, Your Honor.
All right.
Apologies. One more thing, Your Honor. If a bond was to be given, the state will request a higher bond be given.
All right, at this time, the defense request is denied without prejudice. Okay, go ahead. Okay. All right, that concludes this. All right, Gary Harrison.
Yes, sir.
19 CF 15655.
All right, now, sir, you've got you're out on bond on you're released on recognizance on a case. That would not be changed. And there's a new case here, possession of methamphetamine, ecstasy. Your bond is $1,000 as to that. Do you want me to appoint a lawyer for you?
This is sir.
You don't know what you trying to do, bro.
Sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, and that's Division 17, case ending in number 15655.
Okay.
All right, the next file I have here is that of David Lee Hawley. That's 19 CF 15647. All right, now, sir, your name, please?
David Lee Polly.
And sir, you have these charges: battery on a law enforcement officer, no bond; resisting without violence, no bond; trespass on property after warning, bond $100. Do you want me to appoint a lawyer for you?
Yes.
All right. Office
Yes.
of the Public Defender is appointed. That's Division 12. All right, on trespass, a bond was set at $100. And on the battery on the Leo and resisting with violence, these were originally set at no bond.
Your Honor, the bonds are set at 0 until he comes in front of initial appearance due to the nature of the crime, Your Honor. So,
And what is the request of the defense as to the amount of bond?
I believe there's a bond schedule up there, Your Honor. I believe that states what the amount is for the,
It was $2,500 for the battery on law enforcement officer, and the resisting was $150.
All right, and what did you say
Your
as to
Honor,
count two?
The battery on law enforcement officer was $2,500, the
Right.
resistant is $150.
All right, then that would be the amount of the bonds established by the court at this time. And that would conclude this case for the moment. Your name, sir?
Vito Salerno.
All right. Sir, you have a set of matters here. You are released on recognizance on possession of synthetic cannabinoids, and that is stayed at this time. You have a violation of a city ordinance. And there appears to be probable cause in regard to that. That bond is $250. You want me to appoint a lawyer for you?
Huh?
You want me to appoint a lawyer for you?
Yes.
All right, the Office of the Public Defender is appointed, and that's Division A, and that's, let's see, case 19MO 1835AO.
Your Honor, I just see if the state has an offer due to be a city and county ordinance, if they have an offer today for my client to resolve the matter.
The state does have an offer. It would be adjudicated guilty with credit time served 2 days.
And court costs $273.
Your Honor, my client accepts the offer of adjudication guilty, credit time served, and, Your Honor, thank you.
All right. And, sir, do you understand you'd be forever giving up your right to a trial? Yes, no?
Yes, sir.
All right. Please accept it. There's a factual basis set forth here. And so there would be an adjudication, 2 days, credit for 2 days, time served, $273 in court costs payable within 1 year. And 30 days to appeal. If you cannot afford a lawyer, one to be appointed. All right, the next file is that of Philip Bryant. Is that you, sir?
Yes, sir. Philip Bryant.
All right, Mr. Bryant. Sir, you have a set of charges here. Resisting an officer without violence, bond $500. Trespass on property after warning, bond $500. There is a factual basis stated here. Now, sir, do you want me to appoint a lawyer for you?
Yes, please.
All right, Public Defender appointed, Division A. And that's 19 MM 9126.
Mr. Danhauser is behavior, Your Honor.
You said that was Dennis Danhauser?
Yes, Your Honor.
All right. Then reset. All right, the next file I have here is Thomas Lawson III. That is an out of Seminole County warrant, and that was set in by the judge there at no bond. So you'll be transported to Sanford to take care of the situation there. All right, the next file I have is that of Kenneth Banfield,
Yes.
and that's case number 2019 MM 9121. All right, now, sir, you have a charge here, trespass on property after warning, bond $500. Do you want me to appoint a lawyer for you?
Yes.
An offer from the state?
Yes, Your Honor, there is an offer to be adjudicated guilty, but 2 days credit time served.
Your Honor, my client accepts it. Please, no contest, adjudication guilty, credit time served.
All right, there is a factual basis set forth here. So the plea would be accepted, there'd be adjudication, 2 days credit for 2 days time served, and $273 court costs payable within 1 year. So, sir, you understand you'd be forever giving up your right to a trial,
Yes.
all right? And that concludes the matter for the moment. All right, next file I have is that of Sylvester Edward Blue. Is that you, sir?
My name's Sylvester Blue, too.
All right. Are you saying your name is followed by the second?
I see my name, my school name, when I wrote in, my name is Sylvester Blue, too.
I think he was just saying also, I believe there's a possibility he was, can you just say?
I'm my own lawyer today, that lady said.
If you just say your name.
My school name that I wrote in is Sylvester Blue. My school name, when I wrote in school, my name is Sylvester Blue.
All right.
And Sylvester Blue just a name that my other name is saying. That other name
All right.
wrote in.
Sir, you have an allegation here of exposure of sexual organs. Bond is $500. I don't have the application for criminal indigent status, so, all right. Previously appointed in regard to this case, and according to the paperwork here, that's Division CRA, it says. All right, the next file I have is that of Michael Allen Taylor.
What's going on? Sir?
What's going on with the case?
What's going on?
You're in court,
Huh? What's going on?
and now you're going to be placed back in the,
Not the case, what's going on? What
that's everything I can tell you, sir, for the moment.
I hope you don't pull that shit with me, bro. I'm special custody, bro. I'm in some murder who the fuck ever I feel like it. And I ain't in custody yet. I'm a transformer. So you fuck with me, you fuck with me, and you will get yours. Straight up. I'm the number one black man. You think I'm playing with you, nigga? Do not release me for that bag of me. Understand? Today, and you will die, bro. That's all.
Your Honor,
I don't give a fuck.
I think at this point in time, waive is the first initial appearance, Your Honor.
All
The
right.
public defender's office is appointed, stand
me back in here, you think I'm
All right. Well, sir, that concludes the case at this time.
All right.
Your Honor, just to clarify that you waived the initial appearance?
Yes. Public Defender's Office is appointed.
Yes.
Okay.
All right. Your name, please?
Adriana Augusto.
All right. Now, in regard to the Michael Allen Taylor case, 2019 MM 9107, we have bonds, $100 on trespass, threat to law enforcement, bond $500, petty theft, bond $100.
And you're going to take no action on the out on bond?
Right.
Mr. Taylor, okay, thank you.
All right, the next file I have is that of Adriana Augusto.
Yes, sir.
Ma'am, you have a charge of grand theft, third degree, more than 300, less than $5,000. Your bond at this time is $500. Do you want me to appoint a lawyer for you?
No, sir. Yeah, yes, I do. Yes, I do, sir.
All right, Office of the Public Defender is hereby appointed, Division 19, Case 2019 CF 15651.
Your Honor, if I may, my client qualifies for PTR, and she has 0 felonies, 0 misdemeanors, and 0 failure to appear. So I'm asking the court, instead of a bond at $500, that we put my client on PTR.
All right, State, take any position on that?
No, Your Honor.
That request is granted, and the PTR request would be imposed here. All right, your name, please.
Cynthia Amino.
All right, ma'am, you've got a set of charges here. Possession of fentanyl, bond $1,000. Case ending in number 15657. And then another allegation here of driving while license suspended with 2 prior convictions, bond $2,500 on that. So your total bond is $3,500 total as to both cases. Now, ma'am, do you want me to appoint a lawyer for you?
Yes.
Public defender is hereby appointed. We have Division 10 in regard to the drug case, which ends in number 15657, and $2,500 in regard to the driving while license suspended case, Division 12, 15656, case number. Now, you do qualify for the Office of the Public Defender. So, at this time, the Office of the Public Defender would be so appointed. All right, the next file I have is that of Jean Carlos Casilla Ortiz.
Yes.
All right, sir, we have a case here involving allegations of robbery, bond $5,000, attempted carjacking, bond $150, criminal mischief, bond $150, and battery, bond $100. This case ending in number 15634, Division 10. Now, sir, in regard to this, do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is appointed. Division 10. And that's all for the moment. All right, your name, please?
Carlene Casillas Ortiz.
All right, ma'am, you've got a set of charges here. Well, first of all, you are out on bond on a criminal mischief case. That bond is stayed. That remains in effect. Now, this other case, this new case here, robbery, bond $5,000, attempted carjacking, bond $150, battery, bond $100, and if I didn't announce it before, that's case ending in number 15635, Division 14. Do you want me to appoint a lawyer for you?
Yes.
The Public Defender's Office would be appointed, Division 14.
Your Honor, I apologize. What were the first two bond amounts?
5,000 on robbery and attempted carjacking, bond 150.
Thank you, Your Honor.
All right, your name, please.
Joseph Haidi Jubler.
All right, sir, you have a charge here, possession of cocaine, bond $1,000. That case number ends in 15649, Division 22. Do you want me to appoint a lawyer for you, sir?
Yes, Your Honor.
Public Defender is hereby appointed.
Thank you.
All right, that's all for the moment. All right, your name, sir?
Wael Griffin.
All right, Mr. Griffin, you have a charge here of driving while under the influence and possession of hashish. Your bonds are $500 on count one, $1,000 as to count two. Now, sir, you filled out the application for criminal indigent status. However, you do not qualify for appointment of the office of the public defender. So that's Division 15, case ending in number 15650.
Your Honor, we did qualify Mr. Griffin for pretrial release.
All right, then so ordered.
Thank you.
All right, the next file, ma'am, your name, please?
Tyaria Hamilton.
All right. Ma'am, you have a charge of grand theft third degree, more than 300, less than $5,000. Bond is $500, and that is case ending in number 15652, Division 14. Do you want me to appoint a lawyer for you, ma'am?
Yes, sir.
Public defender is hereby appointed. And that is all in regard to this matter. All right, your name, please?
Angela Home.
All right, ma'am, you have a set of charges here. Trafficking in methamphetamines, bond $100,000. Possession of fentanyl, bond $150,000. Possession of cocaine with intent to sell or deliver, bond $150,000. Possession of alprazolam with intent to sell, bond $150,000. Possession of drug paraphernalia, bond $100. Possession of steroids, bond $100. Now, you are out on bond on another drug charge. That bond would be stayed considering the new bond on count one of $100,000. Now, your case is assigned to Division 16, case ending in number 15648, and public defender.
Your Honor, if I may be said, be heard on the bond. My client, Your Honor, she has 0 felonies, misdemeanors, and failures to appear. Also, I do realize that she's out on bond, but looking at the arrest affidavit for this charge, there is a little confusion, and I'm not going to argue probable cause, but it does talk about 2 search warrants. The first search warrant, halfway down, it says during the first search warrant, and this is where they talk about all the quantities the drugs are found. However, reading the beginning of the arrest affidavit, you see that they're talking about the second search warrant that was taken, where my client allegedly was in the house at that time. So again, I'm not arguing probable cause at this point in time, but I believe due to the arrest affidavit not having further information or explanation about the 2 warrants to search the premise, that we have a reasonable bond on the $100,000, and we set it at $20,000 at this point, Your Honor.
All right, state input.
One moment, Your Honor. Does the defendant have any failure to appears? No. Then the state has no objection.
To what specifically?
To altering the bond to a lower amount. I believe $20,000 is what the defense recommended.
All right. Count one, instead of 100,000, would be $20,000, considering the fact that there's already $30,000 posted. All right, your name, sir?
Marcus Devon Johnson.
All right, sir. Let's see, you have a set of charges. The simple one is a violation of probation out of Hillsborough County. So to answer that charge, and you're in no bond status there, to answer that charge, you'd be transported to Hillsborough County. And then you have here possession of methamphetamine with intent and resisting without violence, bond $15,000 and $500 respectively. And that is case number 15667, Division 15. Now, as far as a lawyer is concerned, you do qualify for the appointment of a lawyer. Do you want me to do that at this time?
Yeah, I need a lawyer.
All right, public defender's appointed.
Can I ask him? Hey, Judge, can I was trying to see if I can get my bond lower on the $15,000 bond.
All right, let's see. Want to look at something else.
Your Honor, my client's objective at this point in time is to be able to bond out on these current charges so he can go take care of his out-of-county probation. So with that taken into consideration, we know that if he bonds out here, he's going to be going out of county to take care of that. So that $15,000 at this point in time is too high for him to achieve his objective.
All right. What specific request is there as to the amount of the bond?
Like $200-300, like $200.
All right, state's response.
The state does object because the defendant has a extensive history with past drug offenses and multiple failures to appears in the past.
So, are you saying he does?
He has extensive drug history, and how many failures to appear is the defense? The defendant has 7 failures to appears in the past, so the state objects.
Your Honor, if we can lower it to $1,000, again, his objective is to pay the bond and go take care of his out-of-county probation, which once he posts his bond, he would be sent to his out-of-county.
Well, in regard to that request, I want to look at one of the things. All right, anything further from the state?
Nothing further, Your Honor.
All right. All right. Then, in regard to the defense request, the request is hereby denied. All right. Next case is that of Lamar Jordan, case ending in number 15643, Division 19. Your name?
Lamar Vallis Jordan.
All right, sir. You've got attempted throwing or shooting into an occupied vehicle. Bond is $2,500, and a charge of criminal mischief, bond $100. That's, to say, Division 19.
Your Honor,
Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, public defender's appointed.
Your Honor, this time, may I ask decrease the bond from $2,500 to $1,000? My client does have one failure to appear, but it was in January 2017, but again, it's one failure to appear. He has a misdemeanor and 2 felonies. But the $1,000 will allow him to bond out this time, more likely than not, Your Honor.
Let me get something. All right. In regard to that, the defense request is granted as to count 1, but also there's an added condition, no victim contact.
Yes, sir.
What amount was the bond lowered to, Your Honor?
1,000.
Thank you, Your Honor.
Okay, have a nice day.
All right, next file is that of Bernard Keaton. Is that you, sir?
Yes, sir.
All right, sir, you're here in regard to a set of charges, sale and delivery of methamphetamine, ecstasy. According to the paperwork, you're released on recognizance on that, and then the same charge again, bond $1,000. Now, if I didn't announce it before, case number 15459, Division 16. Now, sir, you have completed this application for criminal indigent status. However, you don't qualify for appointed counsel. So at this time, your request to have a lawyer appointed is denied, and that's without prejudice to make that request at a later time also. All right, I believe that's all we can do right now. All right, the case. Is that Dyson Breath?
Yes, sir.
That's you, sir? All right, sir. A set of charges here. Possession of methamphetamine with a weapon, bond $2,500. Carrying concealed firearm, bond $2,500. Possession of cannabis, bond $250. Possession of drug paraphernalia, bond $250. Case number 15654, Division 11. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, and again, that's Division 11.
Your Honor, at this point in time, may I ask to decrease his bonds to 1,000, 1,000, 250, 250? My client, it shows what I'm reading right now, he has no criminal history, i.e. there would be no failure to appear also, Your Honor.
All right, so specifically, what's your request again?
Possession of meth with a firearm, that would be from 2,500 to 1,000, and carrying a concealed firearm would be 1,000. The two remaining charges would stay at 250, Your Honor.
All right, and state?
The state objects to the first two merely because the nature of the charges, and does the defendant have any failures to appear?
No.
Okay, merely because the nature of the first two charges with the firearm, the state objects.
All right, I want to look at something again. All right, then as to count one, the bond would be reduced to 1,000. Count two would be stayed at 2,500. All right, your name, sir?
Colori Miller.
All right, Mr. Miller, you've got a set of cases here. You've got one ending in number 15646, Division 10. And then a Seminole County case, violation of probation, on which you're in a no bond status. On the Orange County case, bond is $1,000. As to the Orange County case, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is hereby appointed, and the Orange County case again is Division 10. And there's no bond on the Seminole County case.
Denise Rosas, bondage, Your Honor.
All right. Denise Rosas bonded. All right, next file is that of Hector Sierra, case ending in number 15653, Division 20. Is that you, sir?
Yes, sir.
All right, sir, you've got a charge here, sexual battery with a deadly weapon by force. You're in a no bond status at this time in regard to that. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, and that is, again, Division 20.
Your Honor, if we may be heard on bond?
Yes.
His bond amount was set to zero until he sees initial appearance, Judge. I'm not sure at this point in time if the state is going to argue.
Proof evident presumption, great, yeah. Well, thank you
no,
for.
please, yes.
Yes.
No, please, if the state would like to go forward with their argument for proof evident.
Yes, Your Honor, the state argues no bond in this case as there's a victim identification and as well as a photo lineup and witness identification. So the state argues that in order to ensure the safety of the victim as well as the community, the state requests no bond on this case.
And Your Honor, if I may be heard?
Go ahead.
Again, taking the four corners of the arrest affidavit, if we look at the arrest affidavit, there are no statements from any of the witnesses in the arrest affidavit, so at this point in time, it's alleged victim's recollection, her statements in it. The client, there is no, my client did not confess, and also too, more important, that there's no physical evidence of alleged attack. As such, the facts do not support that. The proof of evidence is great, proof of guilt is evident, or the presumption is great, Your Honor. And also too, I'd like to take a look at, my client does have an arrest record of 4 felonies and 5 misdemeanors. However, he has 2 failures appeared, with the last one being in 2014. So I ask the bond at this point in time be set at $15,000, Your Honor.
All right, I want to finish reading the charging affidavit again. All right, anything further from the state by way of response?
Merely that the defendant's history does show he has aggravated. He has had a battery domestic violation and incidences of violence in his past before. So the state again requests no bond.
Well, at this time, the defense request is denied without prejudice. Your name, please.
Amy Smith.
All right. Your name once again?
Amy Smith.
All right. Thank you. All right, now, ma'am, you've got a charge here of driving under the influence of alcohol or drugs. Your bond at this time is $5,000. There's allegation that it's your third violation within 10 years. That's not, however, why you were arrested. Now, do you want me to appoint a lawyer to represent you?
I'm going to try to get a private attorney.
All right, and you also did not fill out the application for criminal indigent status. So you can make that request later if you want to do so.
Your Honor, as a friend of the court, may I bring in regards to her bond? I think it might be counterintuitive what I'm about to say, but I believe it goes to the matter of bond for the purposes so she can be released from jail. She has a criminal record with 6 felonies and 7 misdemeanors. However, I think if we take a look at that criminal record, she had 0 failures to appear. From my standpoint, public defender and counsel, I look at the bond as to ensure that she shows up to any court dates or in court itself. Again, she has 0 failures to appear with that criminal history. So I ask that bond be set at $1,000, Your Honor.
All right, and state's response?
The state objects, given the defendant's past DUI history, and that this being her third violation, like as you said, within 10 years, the defendant also has a extensive history of disorderly conduct and as well as possession and DUI damage to property. The state objects to bond to lowering the bond.
At this time, the defense request is denied without prejudice. All right. Your name, please?
Latoya Tulloch.
All right, Ms. Tollett. Ma'am, you've got a case here involving an allegation of failure to appear in court as required on a possession of cocaine case. At this time, you're in a no bond status. Now, question, public defender previously appointed on this case? All right, yes. So the Office of the Public Defender was previously appointed, Division 14, and case ending in number 3401. Your name, please?
Emily Wetstein.
All right. Ma'am, you've got also a failure to appear allegation with a no bond status at this time. Now, ma'am, do you already have a lawyer appointed on this case or hired one?
No.
All right, do you want me to appoint a lawyer for you?
Yes, Your Honor.
All right, public defender is appointed, case ending in number 3516. And Division 16. All right, sir, your name, please?
Brandon Whitehead.
All right, now this is case number 2019 CF 15523, Division 14, first-degree murder allegation with a firearm, no bond at this moment. Now, sir, do you want me to appoint a lawyer for you?
Yes. Yes, Your Honor.
All right, Office of the Public Defender is hereby appointed to represent you. And it appears that's Division 14.
Your Honor, at this point in time, may I be heard on the matter of bond, Your Honor?
Yes.
And I'm sorry, Your Honor, Edith Bush for the state. May the state approach with additional documentation for the court with regard to this matter?
All right.
And defense counsel is already in possession of that documentation.
All right.
And Your Honor, the state is also going to make another suggestion. I know that the court is planning on doing a move-up docket today so that the court, along with defense counsel, has time to adequately read the documentation. Could we possibly call Mr. Whitehead during the second half of this session, the morning session, session 2, that's going to be moved up?
Oh,
Yes, Your Honor.
all right.
The public defender officer has no objection to that.
Well, we'll do that.
So if we could call him at the end of session 2 to give everyone some time to read the documentation.
All right. All right, next file is that of Daniel Gainey.
Daniel Mark Gainey.
All right. Now, sir, you have an allegation here on a case, urinating or defecating in public, bond $250. And in regard to this, let's see, case ending number 1833, Division A. Sir, do you want me to appoint a lawyer for you?
I've already got public defender, sir.
All right, so ordered. And is there any input at this point as far as whether or not there has been any agreement on the case?
Your Honor, at this point in time, the state's making an offer of adjudication guilty, 4 days Orange County Jail with two days credit, and there would be court costs. Let me just ask my client really quickly. Your Honor, my client accepts the offer of adjudication guilty, 4 days Orange County Jail, 2 days credit, and there would be court costs.
All right, so, Mr. Gainey, is that what you want to do?
Yes, sir.
And do you understand you'd be forever giving up your right to have a trial?
Yes, sir.
All right, then the plea is accepted. There's a factual basis set forth in the charging affidavit. There would be an adjudication, 4 days, Orange County Jail with credit for 2 days, time served, $273 in court costs payable within 1 year.
Yes, sir.
All right, sir, your name, please?
Clinton Milton Gano.
All right, thank you. Now, is there any offer on this case from the state?
Yes, Your Honor. It's an adjudication of guilt, credit time served, court costs.
Your Honor, my client accepts offer, please, no contest, adjudication guilty, credit time served with court costs.
All right, that's case ending in number 1834, Division A. All right. So, sir, do you understand that you are forever giving up your right to have a trial if we go forward on this?
Yes, sir.
Is that what you yourself want to voluntarily do?
Art, my hearing's real bad, sir. I'm sorry.
All right, is that what you want to do?
Yes, sir.
All right. There's a factual basis here. The plea would be accepted by the court. There would be an adjudication, 2 days credit for 2 days time served, $273 in court costs payable within 1 year, and 30 days to appeal. You cannot afford a lawyer when to be appointed. All right, Freddie Thornton case, looks like ending in number 1836. All right. Sir, your name, please.
Freddie Thornton.
All right. Now, in regard to this case, let's see. Sir, you want me to appoint a lawyer, is that correct?
Yes, sir.
Public defender appointed. And input from the state?
If I may, Your Honor, just one moment with the state on regards to this matter, Your Honor.
Yeah.
I know. I guess mine.
Your Honor, the state is making an offer of adjudication guilty, 4 days Orange County days, 2 days credit time served, and there'd be court costs. Let me just talk to my client really quickly, Your Honor. Yeah.
All right.
Your Honor, my client accepts the offer of adjudication guilty, 4 days Orange County Jail and court costs, Your Honor.
All right. So, Mr. Thornton, you understand you'd be giving up your right to have a trial if we go forward with the plea at this time?
Yes, sir.
All right?
Yes, sir.
Then the plea would be accepted, adjudication of guilt, 4 days jail with credit for $273 court costs payable within 1 year.
Nathan Franklin is medical, Your Honor.
All right, reset. All right, sir, your name, please.
Michael LaValle.
All right, sir. Sir, you have a charge here, resisting an officer without violence. Your bond is $500. Case ending in number 9130, Division A. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender appointed. And is there any offer from the state at this time?
The initial appearance offer would be an adjudication of guilt, 10 days Orange County Jail, 2 days credit time served, and court costs.
He is on felony probation also. He's here on the VOP.
Your Honor, at this point in time, the Public Defender's Office appreciates the state's offer, but we'll have to decline it, Your Honor.
All right. Let's see, I believe that's everything then. Case ending in number 9130.
And Your Honor, the bond was stayed.
Yes.
Thank you.
All right, your name, please, ma'am.
Mia Nazario.
All right, ma'am, you've got a charge here, petty theft of $100 or more. Your bond is $500, casing in number 9136. And in regard to this, you didn't fill out a request for a lawyer to be appointed. Public defender, know if you have prior representation?
I do not know this at this time, Your Honor.
If I can get help with the public defender, that's fine, but I really just would like to know what the state would like to offer me.
The state first wants to put on the record she has a prior theft conviction, so this would, as best I can tell, be a second conviction. It would be an adjudication of guilt, 7 days Orange County Jail, 2 days credit time served, no return to the Neiman Marcus at 4170 Conroy Road in Orlando, and court costs, and abide by all trespass warnings.
Your Honor, has the Public Defender's Office been appointed so I can advise her in regards to what the state had brought up about the enhanceability of the crime?
All right, so ordered.
Yeah, I do.
Your Honor, my client accepts the offer of adjudication guilty, 7 days, Orange County Jail with court costs, and she pleads no contest, Your Honor. And she was made aware of the enhanceability of the charge, Your Honor, for the future.
All right. So, ma'am, you understand you'd be giving up your right to a trial?
Yes, sir.
All right. There's a factual basis stated in the charging affidavit. Please accept it. Adjudication of guilt is imposed. 7 days Orange County Jail, credit for 2 days time served. No return to this location at 4170 Conroy Road in Orange County. And court costs would be imposed, $273 payable within 1 year.
Okay. Thank you. Thank
Yes,
you.
ma'am.
Have a good day.
All right, next file is that of Jeremy Rogers.
Mr. Rogers refused to attend, Your Honor.
All right, reset. All right, your name, sir?
Ted Sharon.
All right, sir, you've got a couple of things here. Obstruction of traffic to solicit without a permit, your bond is $250. And then another similar case on which you are released on your own recognizance, same type allegation. That situation is stayed.
Your Honor, he's not out on bond. I'm sorry, Your Honor. Who?
ROR, according to the paperwork.
Okay, we're Justice Rogers, Judge? Oh, okay.
This is Mr. Sierra. But I'm
Right,
not
he's not
showing
out on
him.
bond.
He's not
That's
out on
not
bond either, or on, he's not out on release either.
All right. So, in regard to this case, is there any offer from the state?
Yes, Your Honor. My client pleads no contest. It accepts the offer of the state, which is adjudication guilty, 4 days, Orange County Jail, and court costs, Your Honor.
All right, now, sir, do you understand that you'd be forever giving up your right to have a trial on this case if you go forward with a plea?
Yeah.
All right, there would be an adjudication 4 days with credit for 2 days' time served. Court costs $273 payable within a year. 30 days to appeal if you cannot afford a lawyer, one to be appointed.
I'm sorry, Your Honor, he was out on ROR. It was, the fact detainer wasn't pleased. But you're correct, he was out on ROR.
Okay.
You want to take no
Stay.
action, Your Honor? Okay, thank you, Judge.
I apologize, was it they stated, okay.
All right, next file I have is that of Carlos Torres Carden.
Yes, sir.
All right, sir. Sir, you've got a case here involving a Seminole County warrant. And let's see. Bond is $3,000. So if you don't post that bond, you'll be transported to Seminole County to answer to the charges there. All right, your name, please?
It's Courtney Bossy.
All right, according to this paperwork, we've got a Brevard County warrant with a $1,000 bond on obtaining food or lodging with intent to defraud. And then, according to the paperwork, it says here, out-of-county warrant bond $1,000, out-of-county warrant bond $250, and then there's a note here, court to determine bond amounts because they're unclear to the judge. And then there's more paperwork here, 2 out-of-county warrants, Brevard County, with no bond. And then other paperwork here that says Brevard County $1,000 bond. So, looks like there's 2 judges that the amount of bond appears to be in conflict. Then another case here, failure to appear, bond $2,000 on an Orange County case, number 5122, Division 83. Okay. All right, the next file I have is that of Ishmael Sanchez. There's 3 cases according to this. Let's see. Violation of probation, case ending in number 5583, no bond. Then, and that's case 5583, in fact. No, that's- All right, there's other paperwork here on a case ending in number 15630, possession of methamphetamine, bond $1,000. All right, now, sir, do you want me to appoint a lawyer for you?
Yes, sir, please.
Public defender is appointed.
Your Honor, was there no bond? I apologize, on the failures to appear in the violation of probation? No bond?
Yes.
Okay.
All right, then it would appear we've finished with the morning session.
Your Honor, before we leave, Mr. Sanchez, was the bond stayed in 2019 CF 15630? Thank you. Thank you.
All right, so how much time is defense requesting?
If I just have a couple minutes, my colleagues upstairs were working on the cases, so I just need to know if they're finished. And at that point in time, if they're finished, it'll be not
Okay.
much time, Your Honor.
All right.
And since this is reset, just put him in order down here.
Since we're not gonna hear his cases more, do you still want him in, or we don't need to bring him in? We'll bring him in first. So
All right.
basically on the rest of them.
All right. Court's in session. If council would please announce their names for the record.
Daniel Brisbane for the State Attorney's Office.
Adam Scholl with Office of Public Defender.
All right. All right, the first bit of paperwork I have is that of Brandon Whitehead. Is that you, sir?
Yes, Brandon Whitehead.
All right.
Your Honor, at this point in time, the state and I have confirmed, the public defender, Mr. Whitehead's counsel, that we asked for this to be reset tomorrow so that we can have a conversation in regards to bond, Your Honor.
All right. Considering the paperwork that I've had a brief chance to review, that would seem to be very appropriate.
Thank you, Your Honor.
So ordered.
We'll see you tomorrow, right? All right, now the first file I have is that of Jason Smalls.
Yes, sir.
All right. Now, all right, Mr. Smalls, do you want me to appoint a lawyer for you in regard to this case?
Yes, sir.
All right, now this is case ending in number 8249, Division A. It's a case involving a DUI charge. So, Office of the Public Defender is appointed. So, that says counsel.
I believe the state has an offer, Your Honor,
All right.
of adjudicated guilty with credit time served.
Your Honor, just one moment, Your Honor, please. Your Honor, may I speak to the state for a second, Your Honor?
Yes.
After further consideration with the defense, the defense counsel, Your Honor, the state would like to revoke its offer.
The state, what?
Revoke its offer.
All right. Then, let's see, we have the public defender involved here, so we have the paperwork appearing to be a prima facie case. So, the bond is in the amount of $1,000. And again, that's Division A, case ending in number 8249.
Yes.
All right, Christopher Woodcock?
Yes, sir.
Woodcook?
Yes, sir.
All right, sir, you've got a charge carrying a concealed weapon, an unlicensed electric weapon. Bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes, I would.
All right. Office of the Public Defender is appointed. Division A.
Your Honor, may I speak in regards to bond, Your Honor?
Yes.
He does qualify for a PTR, and also looking at his criminal record, Your Honor, he has 0 felonies. He does have a misdemeanor, and he does have a failure to appear, but it's 1 failure to appear in 2017, Your Honor. At this point in time, I ask that we go forward with the PTR that has been recommended. Well, he's qualified for, I should say.
All right, and State?
The state has no objection.
All right.
Just
All right, your name, please?
Jamar Shabani.
All right, sir, you've got 2 charges here. Grand theft, 3rd degree of motor vehicle, bond $1,000. Trespass in a conveyance, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, Office of the Public Defender is appointed, case ending in number 15665, Division 19.
Your Honor, may I speak about bond, Your Honor?
Yes.
Based upon the facts of the case and also his criminal history, which is 0 felonies, 3 misdemeanors, but he has 0 failures to appear for the purpose of bond, I take the approach, I believe that's important. But the facts of the case in itself, I am not challenging probable cause. However, if we look at the arrest affidavit and everything in the 4 corners of it, my client never acknowledges or even comes close to saying that he was aware that it was a stolen vehicle, allegedly stolen vehicle. So if we look at the facts of the case, again, I'm not arguing probable cause, but I believe based upon that we should have his bond at grand theft 3rd degree motor vehicle as ROR and the trespassing conveyance as ROR, Your Honor. Thank you.
All right, State?
the state objects because of the defendant does have a past history of does have a past criminal history, and in the case in question, the arrest affidavit, the officer did observe the defendant behind the wheel of the vehicle in question, as well as having the keys in his pocket.
all facts for purposes of this hearing considered, the bond as to each count would be $100. So count one reduced from 1,000 to 100. Your name, sir?
Earl Dint-Want.
All right, so this, all right, sir, you've got a set of charges, new charges here. Grand theft, third degree of motor vehicle, bond $1,000. And you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender's appointed. Case ending in number 15659, Division 14. And no action taken in regard to the prior bond situation. All right, your name, sir?
Angel Melendez, sir.
All right, sir, are you Angel Luis Melendez Jr.?
Yes, sir.
All right. Now, this is case ending in number 15661, Division 11. Sir, you've got several charges here. Possession of methamphetamine, bond $1,000. Introduction of contraband into a county facility, bond $150. Possession of paraphernalia, bond $100. Possession of cannabis, bond $100. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed, and that's Division 11.
Gregory Palermo is in the hospital, Your Honor.
All right, reset.
Sabi Pate is medical.
All right, reset. Then the next file I have is that Brittany Spence.
Yes, sir.
Ma'am, you have a set of charges here. Possession of drug equipment for use, and that bond is $100. Then drug paraphernalia, or possession rather, with methaqualone, and bond on that is $15,000. Do you want me to appoint a lawyer for you?
Yes, please.
All right, Office of the Public Defender is appointed, Division 17, case ending in number 15666.
Your Honor, on the
Yes.
matter of bond, if I may?
All right?
Your Honor, first and foremost, her criminal history, she has one misdemeanor in the state of Florida, no felonies, no failures to appear. Also, too, looking at the four corners of the arrest affidavit, there's not much information on into it. And also looking for any information in regards to the charge of possession with intent to sale. I could say maybe there's probable cause. There could even be an argument maybe there's not probable cause. So as to that effect, I would ask that bond at this time, instead of $15,000, be set to $1,000, Your Honor, for the with intent to sell, deliver, based upon her criminal history and the limited information arrest affidavit, and also the possession of drug paraphernalia stay at $100, Your Honor.
All right, State?
Looking at the arrest affidavit, the defendant gave consent to search her purse, and she admitted it was her purse, and the LEO found meth in her purse, and it gave him it up, and she was surrounded, she was with 3 other gentlemen as well. She does not have any failures superior. The state will concede that. But otherwise, that's the state objects to lowering the bond, Your Honor.
Your Honor, again, I just want to show to the court, if we look at the arrest affidavit, I mean, at this point in time, I believe there's actually argument for probable cause, a challenge for probable cause on that statute 893.13, based upon with intent to deliver or sale. Looking at the arrest affidavit, I see nothing in here, any information in regards to weight, anything to that effect in here. All I see is that you can talk about is a field presumptive test kit yielded positive results for meth. So I ask at this point in time, actually, there's no probable cause for possession of methacline with intent to sale or deliver, Your Honor.
All right. Considering the situation here, there would not be probable cause as to count 2, so that...
Well, Your Honor, then the state requests an additional 24 hours to provide probable cause.
Your Honor, I'm sorry, Your Honor. Under further criminal procedure, Your Honor, the court in initial appearance has 24 hours to read the charges to my client. Also, probable cause, they have 48 hours. However, this court, since we have already proceeded or begun with the probable cause determination, the state doesn't have 24 hours, additional 24 hours to get a second bite at the apple, Your Honor. At that point in time, they're saying, please let us get more information, even though there's a arrest affidavit, and we're already having our conversation on probable cause as it is right now.
Well, of course, this arrest affidavit doesn't mean that whatever charge would be filed, so the state... All right, to proceed here, the court would find there's no probable cause, the state can amend, and so the bond is $100, Division 17, and everything else remains the same.
So can you clarify, Your Honor, as to count 2?
Yeah, there is a no bond is required as to the alleged count 2, that the court finds that at this moment there's no probable cause on count 2.
Are you giving the state 24 hours to provide supplemental report, or no?
Yes.
Okay.
You can have that.
Your Honor.
Thank you, Your Honor.
Your Honor, if the state is given 24 hours, which from the public defender standpoint and how I look at the criminal procedure goes against that. But if the state's going to have 24 hours, my client still has to have bond because this isn't a charge of possibility of life. So again, if the state's going to be given 24 hours, I ask at this point in time that bond sent at ROR. My client can bond out in the state. If they have more evidence, they can charge and do an info at that point in time.
All right, well, that's what we'll do at this time, and the state can file whatever appropriate charges they feel are indicated.
So we doing an RR in the company?
Yeah.
Thank you.
All right, looks like the last regular file I have is that of Catherine Wilson.
She bonded, Your Honor.
All right. Now, all right, I also have a file under the name of Jonathan Almeida.
He also bonded.
All right, so noted.
Your Honor, may I? Tomorrow morning, can we, if it's possible with the court, see Mr. Whitehead first in the docket, the gentleman with the first-degree murder, so that way my preparation, I'd be able to proceed with him first. If that's fine with you, Your Honor, and also the state.
All right, so,
Just so that we can see Mr. Whitehead first in the docket, be the first person that we'll bring before this court tomorrow morning.
all right, and that's what I had thought would be the best way to go. Now, that's not to say that that number one case will go for 2 hours or anything. Okay, all right.
Thank you, Your Honor.
Regrettably, then, we